roll call. We've got a guest in the house. We'll start down here, introductions. You have to roll call first. I'm sorry, but I'm sorry.
Okay. Thomas Fleming.
Here.
Greg Boyer.
Here.
Robert Wasco.
Here.
Linda Besser. Here. Thomas Tanner.
Here.
Thank you.
Kevin Wilson, funeral director. Rick Zaborski, funeral director.
Nicole Lewandowski, funeral director.
Kathy Elkins, Funeral Considers Alliance Central Ohio.
Jim Miller, crematory operator. Scott Kelly, attorney representing Fernsville Funeral Service. Mark Forney, funeral director.
Just bought it.
Thank you. Well, item 2.01 on the agenda this morning, it's persons before the board. Nicole Evanosky. Did I get it?
You got it right.
Excellent. Nicole is here to reciprocate her license from Pennsylvania, correct?
Yeah.
If you would like to stand up here, Nicole, at the end of the table here, give us a little background. Just give us a little background on Nicole and
my background, okay, let's see, I have a BA from Seton Hill University, I have an MBA from Seton Hill University. I graduated from the Pittsburgh Institute of Mortuary Science in 2013. I did my internship at Burton Funeral Homes in Erie. They have 4 locations. They do a call volume of about 500. Jump back to when I was in mortuary school, I worked for Service Corp. I worked for a funeral home in Newcastle after I left Erie. William and Roger DeCarbo Funeral Home in Newcastle, Pennsylvania. And right now I'm working at Lane Family Funeral Homes. Obviously you're probably familiar with that. In Austintown, Ohio, I kind of float around 8 locations, call volume of about 1,000. That's essentially that.
any questions for Nicole? Everything in order as far as our side? As far as you know?
Everything is in order.
Are you planning on getting a limited insurance license in Ohio?
Is that to sell premium?
Yeah.
I'm not sure yet.
Okay.
I'm not quite
You were
sure.
thinking about that, but
They've talked about it with me. They said somebody has to fill out a form online.
yeah.
Okay.
So it allows you for a limited license to sell premium as long as you're
Okay. I mean, I'll keep that option. I mean, I'm sure that they'll have me probably do that too down the road.
Did you have any violations against you from state of Pennsylvania?
Oh, no, nothing.
Any other questions? Thank you, Nicole.
Okay, thanks.
Did you make a motion?
Second.
I make a motion to permit Nicole Evan Austin to sit for the board.
Second.
Is that a beautiful call?
Thomas Tanner.
Yes.
Linda Besser. Yes. Greg Boyer.
Yes.
Tom Fleming.
Yes.
Robert Wasco.
Yes.
Thank you. 2.02, Mark Fleming, reciprocating from the state of Washington and the state of Missouri.
Oh, okay. Morning. I started in funeral service in 1990 when I was going to school to become a lawyer. Found a passion for funeral service as I was working part-time in a funeral home and continued on through that my career in funeral service. So I've worked with Service Corporation for 16 years prior to going to work for Stewart Enterprises, and then the merger transpired again. So I'm back with Service Corporation International. And so during my career, I've worked in various states with Service Corporation and Stewart Enterprises. And so I had an opportunity to come to Ohio, which is close to my family in Missouri. So they'd like me to get licensed here in the state.
Do you have a position here in the state?
Yes, I am the market manager for Service Corporation.
expunged from these records we're looking at on this?
Yes.
Linda, are you seeing the content of this?
No, my computer's not running.
Do you want to take a look at Greg's?
No, I read it before.
Okay, thanks. Okay, any questions for Mr. Fleming? Do I have a motion for Mr. Fleming to set for the exam? No motion? Items closed. Item 2.03, Mary Collins.
I don't believe Mr. Collins showed up.
That was just an application to register.
Yes.
2.04, Jim Miller and Scott Gilligan for Princeton Funeral Service.
Okay, we're here for a funeral home license application for the Purnsell Funeral Service. As I understand it, it's staff's position that the building has not received a occupancy permit as a funeral home, and therefore their recommendation not to grant the license. And I just want to point out that, first of all, if you look at your statute, which is on our first page of the handout there, in order to get a funeral home license, you do not have to have a building necessary to conduct funerals. If you look at the definition of a funeral home, it's a place for care or preparation of the body, disposition of dead human bodies, or the conduction of funerals. So in order to get a funeral home license under the statute, the building does not have to be sufficiently large enough to hold a funeral there. As you can see in your regulations there in the second section, direct disposition services, which obviously do not have funeral chapels, still need a funeral home license. So there'd be no way for you to grant a direct disposition service a funeral home license if they had to have a building large enough to have funerals there. If you go down to the next regulation, 4717-7-02, you can see that the requirements to get a funeral home license is that they receive an occupancy permit and pass the inspection by the board. When we turn to the next page, you can see there's the occupancy permit given to this building, Purnsell Funeral Service located 1701 Marion Williamsport Road. If you look down, you can see we've highlighted the use of occupancy group. It's given a B classification. And you can see on the other side the maximum load, the maximum number of people allowed in the building is 8. Okay, so obviously you're not going to be holding funeral services, funeral ceremonies there with 8 people. But that qualifies under your regulations. That's all we need. We have the occupancy permit, assuming we pass the inspection by the board, and that we're managed by a licensed funeral director, owned by or operated, the licensed funeral director ultimately in charge. That is all we need under the statute, and you are required to grant the license. But let's go on and take a look at what the issue is here. If you look on the next page, I have copies of the Ohio Building Code, the applicable section. There at the bottom you'll see there is a classification called Group A. That's for assembly areas. If we look on the next page, you can see there's an exception to assembly area. In order to get the Group A classification, you have to have 50 or more, a building that has space for 50 or more occupancy load of less than 50 persons gets a Class B. It's an exception to a Class A. You can still qualify for the whatever Class A is, you just have a Class B because it indicates that you have 50 or less. So if we want to look at what falls under Class A, you can see there at the bottom of that page, assembly areas include motion pictures, symphony theaters, nightclubs. Look down at A3 on the next page, you see funeral parlors fall under there. So these are all the assembly areas that fall under classification of A. But if it's a smaller, for example, a smaller restaurant, a smaller theater, a smaller funeral parlor that has less than 50, they would fall under B. That doesn't mean they are not classified as a funeral home. It just means they're classified as a small funeral home. And as you can see, we'll go a few more pages past till we get to the Ohio licensing. You can see that this board has granted funeral home licenses to places with less than 50, that hold a load factor of less than 50. I have the Day and Minoski Funeral Home in Gone, Ohio. You can see the license has been issued. You turn to the next page and look at their occupancy permit. You can see they are also Group B, it's highlighted there, and they have occupancy of less than 15 people. Okay, so it's the exact same as what we're doing here, only we have less than 8 people, they have less than 15 people. Group B, they have been granted the license. Go on to the next one, Bollinger Funeral Service in Brunswick, Ohio, also an active license. Take a look at their certificate of occupancy. They're Group M, which means they sell merchandise, retail funeral goods. You can see their occupancy description, and they have an occupancy load of 25 people. Again, granted a license. The next one, Grable Funeral Home, North Canton, Ohio. Take a look at there. They're also a occupancy permit for their Main Street location, given a B classification, just as we had. And they're to be used only as offices and mortuary for embalming services. The same thing we're going to be using this location for, except this location also has a crematory attached to it, an operating crematory. Then that takes us to the final piece here, and this is where the whole issue started, and we went back to the Department of Commerce yesterday, the gentleman who granted the B rating, to get clarification on what does a B class mean versus an A class. And if you look at the bottom, this is a chain of emails, so it's going to go in reverse order. If you look at the bottom, and this is from Mr. Jang, and he, in answer to my questions, he tells me, Mr. Dilligan, a funeral parlor is usually classified as A3 assembly occupancy classification, Section 303, that's what we just looked at. However, as allowed in exception number 1 of Section 303.1 of the building code, that a building or tenant space used for assembly purposes with an occupancy load of less than 50 people shall be classified as a Group B occupancy. The building located at 1701 Marion Williamsport Road, Marion, Ohio, our building, falls under this exception. I then asked him the next question up, just to get clarification. It says, does that mean it can be used as a funeral home, assuming it's licensed by this board, as long as assemblies in the buildings do not exceed the maximum load of 8 persons? His answer, yes. It can be used as an assembly building, which in this case, a funeral parlor for up to 8 occupancy load. So it has received a occupancy permit as a funeral home. It's only a B because it's a small funeral home. It's less than 50, but it does qualify as an occupancy permit for a funeral home. So even though this board doesn't require an occupancy permit for a funeral home in order to be qualified as a funeral home, in this case we actually did receive that. And it'd be my position that you have to grant the license in this case. Now, I know there's been pictures of the building beforehand, before it's been redone, and if you'd like to see the building, we unfortunately just have it on Mr. Miller's phone, but he can show you the pictures of the arrangement office, the entire inside of the building by passing around the phone, the outside of the building, which has been redone, all that's been refurbished. The fire marshal has been in there, approved it. We required them to build a firewall between the crematory and the arrangement offices, but that's all been done. They have a conference center with a glass that people can witness cremations, make arrangements, and it's passed inspections by the fire marshal, by the city. It's got the occupancy permit. It's ready to go. If you want to go ahead,
Mr. Hill,
pass it around.
so this is going to be, the business model is going to be a direct cremation, direct disposal type of?
Yes, the people could witness a cremation if they want to. But yes, it's a simple, more of a discount operation is the business plan of this model.
And by licensing it as a funeral home versus a crematory?
It's so arrangements can be made there.
Okay.
That's primarily the motivation. It's going to be an alternative to a funeral home.
Okay.
Vanessa?
Yeah, just a point of clarification. The recommendation to deny was based on Mr. Zhang's original conversations with staff, indicating and referencing to us on the occupancy permit, if you look at that again, which is page 2, that they were limiting the use to a monument sales and cremation service, and then we had special instruction also that it would be 8 or under. But if Mr. Yang has indicated in response that yes, it can be used as a funeral home, that was our only concern, was that Department of Commerce was both in writing and in the occupancy permit telling us that it could not be used for any other purpose other than what they specifically stated on the permit. So if we have something else in writing from Mr. Yang that resolves the concern that we had from him originally.
Isn't this last piece, isn't he stating that it can be used as a funeral?
That's why I said it resolves the.
Okay. And then if you folks look at these pictures, you know, in your minutes with the agenda, this building, as Mr. Miller was showing, does not look like this building now.
Can I see that?
I had a lot of questions why you were doing this in a garage, you know, but, are you affiliated with the Munster Store?
I am, yes.
You guys just don't want to run that operation out of there?
I think the reason being, the funeral home in Bucyrus is a corporation for Munster and Pernstill. I think Dave took the initiative at this point to open this up for himself. That is something that Dave would have to discuss with you, being that he's not present today. That's his reasoning. The building itself was originally a garage, but we have purchased 7.5 acres down there. The building has been completely remodeled. My phone has a
Is that facility already licensed?
Everything is ADA accessible, fire alarms, alarm systems, properties video surveil. Yes, sir. Everything's
Holding room?
Yes, sir. With
Could you show us that?
I did not have it on here. These are pictures that I took this morning.
Okay.
Okay. But everything has been inspected by all the state agencies that were required. The fire marshal and also the fire chief from the area have inspected it, and we've passed all.
In fact, the only thing they had to do for the board was put a sink into the holding area, and they have done.
Any further questions for Mr. Miller or Gilbert?
Is there a motion in order on this?
We don't have one yet. Any questions?
Yeah, I'd like Make a motion to approve the application.
Second.
Any discussion? Roll call vote, please.
Mr. Mosker?
Yes?
Ms. Dunford? Mr. Boyer?
Yes.
Mr. Cannon?
Yes.
Mr. Jones?
Yes. We had,
Good luck to you.
Thank you very much. Thank you. Happy to say that.
we had a person join our meeting. Sir, do you want to introduce yourself?
I'm Barry Collins.
Okay, we're going to back up to item 03. Did you know our meeting started at 9 a.m.?
I went into the wrong building.
Okay. Mr. Collins, item 2.03, he's made an application to register as a funeral premise here in Ohio. Do you want to stand right over here at the end of the table, Mr. Collins, give us a little background? Obviously, we have a lot of content in the minutes here, and lots of questions. Tell us about yourself.
All right. I am a licensed social worker here in the state of Ohio. I worked for hospice for 7 years. Prior to that, I worked in mental health. I worked with people with developmental disabilities, as well as lots of other groups in the social work field. Coming from hospice into, I worked with funeral homes for years with hospice, so it was kind of a natural transition to come over to the funeral home side. I think I can bring that extra personal touch to assist families during the arrangement process, the whole funeral process itself, and I think I would be an asset as a funeral conductor.
Any questions for Mr. Collins? All the content that is before us, I see that you were released from probation. When was that? 09? Okay. Do you have anything else to say? Do I have a motion to allow Mr. Collins to put application in and register as our address?
So moved.
Is there a second? Motion didn't carry. No seat, sir. That is the end of the persons before the board. If you folks want to stay for our meeting, you're more than welcome to. As we go through it, it's going to be a long day. It'll be a long agenda today. But you're more than welcome to stay, or you can be excused for this time. Item 3.01 on the agenda. Consideration of the February 2015 minutes. Everybody have an opportunity to read those? Review them? Need a motion to consider February 1?
So moved.
Second.
Any discussion?
Yes, Mr. Chairman. As you're probably familiar with the string of emails that went back and forth between myself and the executive director, I had learned that we really don't have an accurate method of recording the minutes of these board meetings. And I was surprised to learn that these are not verbatim minutes, but they include editorial comments from the executive director, which I think are inappropriate. After reviewing specifically the minutes, I specifically noted that when I had asked Ms. Nykamp at the last board meeting, since September, what has this board done to change that problem? Ms. Nykamp responded, nothing new has been implemented. And down in the minutes where it says that TANF retorted 6 months and not a single idea, NICAMP explained the budget, nor budget has picked up any of the ideas. Up above, I had, as I recall, specifically asked Ms. NICAMP that question, and as I recall, the answer to that question was a flat-out no.
Because I'm not where you're at in the minutes, Mr. Tanner, giving you ideas of what? So this is on the minutes?
Correct. Under 6.01. So, I don't know that this is fatal to the issue, but I think it's inappropriate when the minutes are transcribed that they not be verbatim. I don't think it's appropriate for the executive director to modify what I thought was going to be a verbatim transcription based upon an audio. And these are simply not that. I just don't think it's proper for our executive director to be incorporating her own editorial comments into these minutes. So with that said, I had also asked Sergeant Moses to prepare a memo on this issue, and I'm sure that all of you have had an opportunity to review her March 16th memo regarding recording minutes. And her memo indicates that we would probably best be served by having the board meetings recorded, and that she would recommend audio or video recording if this board is concerned with the budgetary restraint of having an actual stenographer in here the way we do on the State Cosmetology Board. The only two other questions that I had for Sergeant Moses, and maybe she needs to explore this and get back to us later, was what I didn't see is how long we have to retain these audios if we do that, and who are they retained by?
There are several different things, and I'm certain she I gave you, I know if you go straight and give you an incorrect answer. These recordings, even if you take just a recording, they need to be kept just like any other record. So they would have to be maintained by the funeral board, and the Attorney General's office has decided that we believe they count, even just recordings, if you're using them to copy notes verbatim, they need to be kept just as any other record, and then in the way that your department does in the funeral board. Or, I'm sorry, funeral record, board of law, funeral records. I keep wanting to call you guys funeral board, I apologize. So, you know what I'm saying here. You would need to keep them that way. You can make them available to the public. Vanessa has said that they can be posted, there's a way on board docs to do that, or you can keep them for yourself, and public records requests can be made, and they have to be made available.
I mean, you know, not to get nitpicky, but I'm going to get nitpicky. At the end of the board meeting, for example, under 10.01, near the end, I had asked to excuse myself, and it's noted in here that Mr. Tanef announced departure from the meeting for a personal appointment. I never said I had a personal appointment. I said I had a doctor's appointment. So this is again an example where these minutes are simply inaccurate. Personal appointment to me would mean maybe I had to meet somebody for a cup of coffee or something like that, and that's not the case. What I specifically said was I had a doctor's appointment.
May I say something, Mr. Chairman? Just a point of clarification. Mr. Tanner asked me to have the person who generated the minutes, as soon as they were generated, send them directly to him prior to me seeing them or editing them. That is exactly what happened. However, I also had them sent to all of the board members and our AAG at the same time. I did not edit the minutes, as you can see from the very top of the minutes, until most recently when I asked the board president if he was okay with me going ahead and making revisions and edits, which was on March 11th. So we have never recorded meetings in the past. We did have a stenographer for only a period of 3 months one time to try to get more, I guess, detail as to what we would want our minutes to reflect. However, the board never approved an expenditure for a stenographer for any period of time beyond that time period. The board had always consistently had a staff member take notes and produce minutes similar to this or in different variations as time periods have gone on, and we've had different attorney generals and different advice. So what you received was exactly what you asked for. So your allegations that there were editorial comments or anything added by myself is false.
I respectfully disagree. Mr. Chairman, that's about all I have at this point. But this issue does need to be resolved. I'm hoping it can be resolved before the next meeting. And I don't know if this is the appropriate time, or we have to do this once we resolve the issue of the specific meetings today. But I would like to see a stenographer in here.
Well, through discussion and talk, obviously the meeting is being recorded today. It's not taking the place of our minutes, but it is a supplement to get more detail if not satisfied with the way the minutes are written. The minutes are written through the advice of Susan Walker, Section Chief of the AG's office, and our former AG here, Carla Downing. So that's, you know, why the minutes are developed, and that's why they're out like they are. But I don't know what the resolution is you want to implement or suggest, or what's on, where are you at with this?
I'd like to see a stenographer.
Just a stenographer. And that would be at approximately, and one email is $26,000 or $28,000 a year.
And with our contract with the stenographer, we're with an MD vendor. We have been told that it would be at least $27,000 a year. We need to attribute at least 100 pages per hour. And then we have a cost per page. We have a cost for the stenographer, and then a cost for the delivery of the transcript.
So that figure you just said, is that total or is that plus?
No, it's total.
So that would
And then
include the cost per
27.
page. Comment?
The only comment I have is that we're going to need that money for representation based on the memo that we refuse representation from the Attorney General's office. I want to have some money set aside to get representation. So I don't really care. The video will be fine for me, but that money should go into so we can hire an attorney that will represent us properly. That's my comment.
If there were an expenditure of $27,000, I would need to go to controlling board to get an increase in appropriation to do that.
Well, you're going to be going for attorney fees anyway. So that's just my comment.
Any other discussion?
I make a motion to approve the minutes. We haven't
I
done
think
that.
you already
Oh,
made
did
a
we?
motion, and I think Linda or Greg
Second.
seconded.
And
This is
Mr.
just-
Boyer, and a second by you, actually.
By me?
Yes.
Okay.
Okay, any other discussion regarding this? Do a roll call vote, please.
Mr. Boyer?
Yes.
Mr. Weston?
Yes.
Ms. Metzger?
Abstain.
Mr. Fleming?
Yes.
Mr. Campbell?
No.
Motion fails.
Item 3.01 is it back on the agenda for the next one?
I need a point of clarification. Do I have another, are we considering Mr. Tanner's request for the stenographer for another motion? Because I haven't had that. Or
That wasn't in that discussion.
I thought you had made the suggestion that while she's going for the money for the legal services, that she would ask about the stenographer.
No.
No, you didn't.
No, I said, take the stenographer's money and put it to the legal services.
Okay. Well, we have representation,
No.
but,
Well, we don't based on this.
Well, you read your emails?
yeah. I mean, like I said, we were also on the cosmetology board in that periods where we had in-house counsel and we did not have in-house counsel. And for the most part, and even currently, we're satisfied with the representation that we get from the assistant AG's office. Or I'm sorry, from the Attorney General's office to the assistant AG. So if you need a motion, then I'm making a motion that we pursue a stenographer to record the minutes.
A motion for the stenographers on the floor, is there a second?
Second.
Any discussion? I have comments, I feel that the recording of the meeting is sufficient with what we already do, as advice from the AG's office. So I don't know if we're going to do that expense. Any other comment?
I highly object to the video recording. I don't see why we can't just have an audio.
Well, it's a public meeting and anybody could actually,
Well, let them come and do that then. But I object to being photographed.
Mr. Chairman, with all due respect, for years we've simply had audio recording of the board minutes on the state cosmetology board. So I think one compromise that would satisfy Linda would be if we simply had an audio recording and not a video recording. And I think that would satisfy the memo that was provided on the recording of the minutes by Sergeant Moses.
any other comments? Roll call, please.
Well, wait a minute,
This is the hire stenographer?
I'm sorry, what's the motion?
I have,
The hire
To
stenographer.
have a stenographer.
Okay.
I can read it back. I have a motion to pursue a stenographer to record the minutes of the board, made by Mr. Tana, seconded by Ms. Spencer. Ready for the vote? Ms. Spencer?
Yes.
Mr. Tana?
Yes.
Mr. Fleming?
No.
Mr. Wasco?
No.
Mr. Boyer?
I want to make a comment before I make a vote. Since based upon the opinion that recording by audio would be substantial, then I will say no.
Motion fails.
All right, I would, Mr. Chairman, make another motion then, is that the board meetings be recorded by audio.
Second.
Any discussion? Motion on the table, consent. Roll call, please.
Motion that the board meetings be recorded by audio by Mr. Tana and seconded by Ms. Spencer. Take your vote.
No, I just like to make, I sit on a board that videotapes and actually puts this meeting on the web so the public can see. And I think I get a lot of comments from funeral directors as I go to some of the district meetings that they can't come to Columbus to view the meeting. And so I actually think that this is a very good and transparent procedure. And I think we'll have a lot of people that are, a lot of our colleagues and licensees that would like to see, you know, our regulatory board in action. So I'm in favor of the video, so I will be voting against that motion.
That's because you haven't had death threats made against you.
Any other comment? Motion's on the floor. Roll call, please.
Mr. Fleming?
No.
Ms. Spencer?
Yes.
Mr. Boyer?
We are, if I make that comment, we are into the future. Things seem to be videotaped in the future. We see it on TV every day. When we go to war, we see it every day. It's something that's happening every day. It is today's technology. So I have no problem with there being video and audio. So. No.
Mr. Tanner?
Yes.
Mr. Wasco?
No.
Motion fails.
Okay, item 4.01 on agenda application recommended for licensure.
I have a question, Mr. Chairman. We passed a resolution in the Disciplinary Consumers based on Susan Walker's advice that you would not be providing, the AG's office would not be providing legal services to us in a public meeting. And so a resolution was passed basically acknowledging that memo. So I guess when we talked to Susan, we said, well, are we able to ask questions? And she says yes, and she could respond to us if she wants or not. So I would say, unless we ask a question, you're just supposed to be a participant in the meeting. I mean, a spectator, not a participant. This is based on Susan Walker's memo to us. And I can show you a resolution that was passed by this board.
No, Mr. Moscow, I understand what you're saying, and I read the resolution and your stuff. Our job is to make sure that you guys don't get into trouble and to clean up the meetings and protect the public interest. So my job is to represent the board and to protect the public, and by doing that, I need to make sure that motions are clean, things
That's
are
legal,
said.
that's legal services in a
That's
public
what
meeting.
I'm going to do.
That's legal services in a public meeting.
Now,
Your section chief says you will not be providing that to us.
what she wanted was that we don't discuss legal cases out in
That's
the
not what the
open
memo said.
unless you decide that's what.
That's not what the memo says.
Mr. Wansco, if I could please. Again, I've been on the state cosmetology board for years and years, and historically, you know, the assistant AGs that are there that represent the board, you know, they change over time, and we have always had not only interjection by the assistant AGs when they thought it was appropriate, or where they saw that we were getting ourselves into trouble, but we've always welcomed it.
We did too.
Well, but for you to say that...
And I've sat on boards for 20 years. I understand. We have a memo
I've
from...
sat on boards for longer than 20 years.
We have a memo from a section chief that said they will not be providing that. We passed a
Is
resolution.
this the memo?
That's the resolution we passed.
Okay, but this isn't even dated. And
It's not dated.
you can pass any resolution you want, but
You asked for it. I'm sorry.
it's my opinion that the sole purpose of having the assistant AG here is to protect us. And if she sees that we're getting into an area that we're not following either proper procedure or of the state law or administrative code or whatever it is that she's here to protect us, I expect her to stand up and speak up.
I totally agree.
Okay.
I'd like to have clarification though from our section chief.
Would you like me to call Susan and see if she's willing to come over right now?
No, that's not
It's
necessary.
not necessary.
This, just to clarify, Mr. Wasco asked me for the exact motion from the prior minutes. The minutes are available on the web, and this is actually the page of the motion just taken straight from the minutes from February the 14th. So I didn't copy all 97 pages of minutes, I just brought in what he asked for.
Come on, it'll be fine.
Was that discussion on?
Yeah, I'm fine.
Okay. We were on item 4.01 on the agenda, applications recommended for license.
Would you like me to review each one, or save exceeding time to get to legislation?
I have no, was there any questions on any of these from anyone? I had a question on one from title. Funeral service by Curious Salat. If I'm pronouncing that right. did we just have a case, probably in the last 4 months, that gentleman was putting his name and title somehow misconstruing it?
No. We have a couple other funeral homes, but not this individual, no.
No, it wasn't this individual, it was a different, one was before us to wanting licensure. I know we went back to him and made him change the order of the, it was similar to this, but
You have done similar things in the past, however, there are people that are funeral homes currently licensed like this. So if we have any that are licensed similar to it, we bring it to you for consideration. Not that you would make the same decision, but there are funeral homes that are where it is funeral services by and then a different individual.
I guess where, I would get the impression as a public or consumer, I see a big sign out there that says funeral service. So if his legal name is funeral service by Gary S. Lott, they all have to be 6-inch letters, or it's funeral service, and then by Gary S. Lott, smaller underneath.
It all has to be visible to the public, so we wouldn't have 6-inch would probably be very, very minute. But yeah, I mean, could they have funeral services larger and then by various spot lower, below it? They could, but currently you have funeral homes that do a similar thing. They'll say, particularly Wasco, and then underneath family funeral services very large. That's not exactly what's happened with Mr. Wasco, but you do have that regardless of which order that they're in.
So, Mr. Chairman, so what you're concerned about is that generic funeral service isn't, foot-high letters and then in 3-inch letters by Gary. I see what you're saying.
Yeah. It's just kind of a deception where we've been, like directions and just naming it in general, funeral service. So, do you know this?
No.
It's up in your areas?
Yeah, I don't know.
And of course, we don't know what the actual signage looks like yet, but all of the documentation that's been provided to us with the letterhead and such does not have it in any different font size or anything different. It's all linear.
All right, Mr. Chairman, but my one concern is under the name change 3038. My understanding was in the title, on the license, we do not have crematory. On the license of the funeral, is that correct?
We do have it on some that are funeral homes that are also licensed as crematory. We've allowed it on both licenses. So both licenses, particularly say in this case, Jennings Farley Funeral Home and Crematory. We've allowed it on both the crematory license and the funeral home license.
We
do have some funeral homes.
Was that grandfathered or?
You have some that are that way, and my only experience with you has been that they had to also have a crematory license, and this one does.
Or crematory on site.
Right, you have had a crematory license. So you've had some that made application to you to say in cremation services, but they didn't actually hold a crematory license, and you had to remove those. But my experience with you is you allowed them, if they did have a crematory license, if there are some that are titled in the last 3 years that way.
I don't have a problem with that. I just want, but that's sort of gray in the rules.
It doesn't say they can't.
It doesn't say they can't. Okay.
Could I have a motion to accept the application for recommended for licensure?
So moved.
Second.
Second.
Roll call vote, please.
Mr. Fleming?
Yes.
Mr. Boston?
Yes.
Ms. Betzer?
Yes.
Mr. Tina?
Yes.
Mr. Boyer?
Yes.
Motion passes.
Item 4.02 on the agenda, it's no motion items, it's for our information only. Does anybody have any questions on any of those? Kevin Coyne, license 2480 at the end. Wasn't he before us? Or isn't he still got a case pending before us? It's not Kevin.
It is not Kevin, it is Michael.
Okay. Thank
It
you.
is called Jack Monroe Clay.
Okay. Item 5.01 on the agenda. Continuing education exemptions.
We have 250 units presented to you and one exemption, and all the paperwork is in order.
Motion to approve.
Second.
Any discussion? All in favor? Aye. Opposed? Item 5.02, recommendation to remove continuing education exemption.
This is basically a request from the licensee.
Yes, he is requested to have the CE exemption removed, and he meets all the requirements.
Motion to approve. Second.
Discussion? All in favor?
Aye.
Opposed? 5.03, applications of individuals, licensees.
These are individuals who took CE credits out of state. They had 30 days to apply once they, at the end of the course for CE consideration back in Ohio.
I thought we were not allowing over 9 hours for one program or one event.
I have that you don't allow over 9 hours of online.
Online?
These were all in-person training,
Okay.
and you don't currently have a restriction on that.
Okay.
Funeral business boot camp. I make a motion to approve. Second.
Any discussion? All in favor? Aye. Opposed? Motion carries. 5.04, continuing education programs recommended for approval. I looked through these, which was very hard to read for me in this format on here. Did anybody see or have any questions on any of those?
Did Danny have any problems with any of these?
No, the only thing Dan's mentioned is that we used to have two processes for obtaining CE as a program provider. One was the blankets, and when the board moved away from utilizing that blanket, we do have some CE providers that every month submit the same 5 courses to offer them to funeral homes, but unless they actually receive a call from a funeral home, then of course those courses are canceled. So we do have some providers now that every month are duplicating maybe the same 5 or 7
So
courses.
it's like, it's not very efficient for either side.
Right.
Because we did away with the blankets.
Is this Insight Institute, you're asking for 17 hours to go through this? Actually, being there in person, that's not.
Yes, it is in person.
Okay. Any other questions regarding the continuing education hours? Can I have a motion to accept the continuing education programs?
Second.
Discussion? All in favor?
Aye.
Opposed? Item 6.01, recommendation to charge.
This is the item that we will not be able to hear until we get an additional licensing appointed to the board.
6.02, recommendation to charge. Any comment on this?
To summarize this case for you, our main concern with this case was the consumers clearly contracted for just a direct burial, but at the time that the services were arranged, both the funeral home and the consumer indicated that at that time they even had a conference call with a minister that all were aware that they would meet at the entrance of the funeral home at 12:45 on the date of the funeral, or the burial, and that they would caravan back to the site, and that the burial would proceed at 1 o'clock, and that the minister and the family members and friends would be graveside, even though they sold it as a direct burial, which would not typically include a graveside service. And, but on the day of the burial, the funeral home actually moved the burial earlier in the day, and that was due to a level 3 snow emergency. The family and friends had previously, prior to the burial, asked if it could be moved to a later time, so that they would not have to travel during the level 3 snow emergency, and refused and were consistently told it would proceed on as it was planned at 1 o'clock. But on that day, that morning, they actually received a phone call. So again, the funeral home included those individuals, letting them know that they were going to proceed, but they were going to proceed earlier. So they scheduled it at 11:30 and gave 2.5 hours notice of changing the time earlier, and actually had it happen during the level 3 snow emergency. So that is why we brought it to you to consider whether you believe it was unprofessional conduct, specifically that the funeral home was aware that the mourners wanted to be present at the burial, but however scheduled the time to occur earlier during the level 3 snow emergency, which gave the attendees little notice and no legal ability actually to get there because they were non-emergency vehicles and were not supposed to be on the road.
Well, one of, Mr. Chairman.
Has the body been embalmed?
No, but they did have refrigeration.
At the time the body went into the refrigeration versus when it came out, and the time of death, and any other details? The 48, my question is, the 48 hours passed from when he was not refrigerated?
No, not that.
Well, it says dated, your 48 hours did that has passed.
No.
So dated, that's with January 27th.
Right, but from the date that they retained the body, they immediately refrigerated.
Okay.
Then the first request was made on February 1st. Is that the burial?
No, February 1st was the second attempt by the mourners to get it moved to a time outside of the level 3. What happened is this individual passed away. The family and some friends of this elderly individual met at the funeral home. At that time, they got on a speakerphone with the minister as well. And this is acknowledged both in the statement from the minister, the statement from people that were at the arrangement conference, and the funeral home actually wrote it in their statement as well. And they made arrangements for the burial on that February 4th. Tuesday, February 4th. Then, at a later time during that weekend, they were made aware that they were going to be under a level 3 snow emergency and that there was a storm coming through, and individuals and family and friends made requests to the funeral home to move it to a later time so that they could make it, and the funeral home consistently said, for their contract, it was a direct burial, it was to be made at the convenience of the vault company and the funeral home in the cemetery, and that they would proceed with the 1 o'clock on the 4th. But on that day, on the 4th, they contacted mourners in the morning, giving them 2.5 hours notice that they were actually moving it earlier to 11:30. And held it during the level 3 snow emergency, which was posted until noon.
I've been trying to put my arms around this, and this is something that my business model, my operation would not do, okay? So I want to put an asterisk there. But as we just saw today, direct disposable companies, discounted operations, you know, you're getting into a scenario where I was reading here that it says immediate burial, it says she she states the funeral home told her they would not reschedule the burial because it was an immediate burial and it would take place at a time convenient for the funeral home, vault company, and cemetery. You know, and some of those restrictions, like if you're buying airline tickets, there's a restriction if you're buying. So I'm having a problem with this. I don't know if this is a business model. Was this disclosed that, hey, this is the price, you agree with it, but this is what we're doing?
And also, I agree with Mr. Wasco. The level 3 snow emergency was in effect until noon,
Yes.
and it was put in place the night before.
It ran Monday through the Tuesday until noon.
Is it possible that, you know, the weather forecasts were, hey, we think it's going to get, the snowstorm's going to get worse, and so these guys wanted to do this earlier, or we don't have the benefit of having these people here. And so what I'm trying to wrap myself around is, were there weather forecasts at that time when this decision-making process was being made that indicated that the storm was going to get worse? And is that why they did it earlier?
No, their indication in their statement was that they did it at 11:30, only because that's what worked best for the vault company, the cemetery, and them. They made no indication to moving it earlier because of the weather.
How much trouble, if you guys were in this situation, you've got the weather to deal with, you've got all these other companies that you're dealing with, how much trouble is it to change all this to orchestrate?
You think to me, they already had everything scheduled for 1 o'clock, with the cemetery opening, with the vault company being there, we're gonna be there for this direct burial. You know, so.
Well, okay, I want to answer this question. So the initial schedule, everyone's scheduled, cemeteries have one, funeral vault companies have one. So the initial schedule takes some coordination, but then they reschedule at last minute. So everyone, and I almost have to, without reading, I almost have to think they moved it up because of the snowstorm.
That's what I think.
That's, you know, but it wasn't convenient for the family.
I'm wondering whether they thought it's going to get worse and we got to get this done.
Yeah.
May I make a statement? Mr. Wasco raises about, actually a great point. We don't know what agreement. Did they have an agreement with the funeral home, a contract that says, hey, we are going to do it at our convenience and we'll try to schedule around you, but no guarantee?
Or was it just in this testimony?
The contract with those were it would be at their convenience, not the owner's convenience, at the funeral home, the vault company, and the cemetery's convenience.
The contract.
Yes. Our concern became in when they clearly gave a time and made arrangements and did that not only with the owners but also with the minister. And for the 1 o'clock time, and even that morning notified them that they were early. So they kept them involved. They knew that they would be graveside.
And they were actually adding services more than the direct burial.
It was, as we went through it, we asked all the same questions that he asked, and what we came up with was that the managers felt that it was unprofessional because they would accommodate something later or even the time that it was committed to.
What was our inspector's view on this? Is that Troy?
Yes, it was Troy. His main concern was having people travel in a level 3 snow emergency, including funeral home staff when they're non-emergency.
First time we've seen this firm before us.
You've not seen the firm before, you know. The firm stands with their statement that the contract was that it was at our convenience, and that the fact that we informed them was a benefit to them, but it was always at our convenience.
Mr. Chairman.
They also did this funeral at a reduced cost because of the funeral home, or the insurance policy collapsed.
No, they did it at their package price for direct burial.
Right, but it was originally said something about traditional.
Yes, it was originally arranged as a traditional burial, however, some of the policy had lapsed. And so then the family changed it along with the funeral home to cover just a direct burial home.
Mr. Wilson?
Had it been advertised, sorry? I was just curious, had it been advertised in the paper, on the website stating 1 o'clock?
No, I did not.
Mr. Chairman, I make a motion to close.
Second.
Further discussion? Roll call, vote, please.
Ms. Spencer?
No.
Mr. Cannon?
Yes.
Mr. Fleming?
Yes.
Mr. Boyer?
Yes.
Mr. Wasko?
Yes.
Motion passes.
Item 6.03, recommendation to issue a cease and desist notice.
This is a very unique case. We became aware that a funeral home and funeral director has started a new program. A new program called the Concierge Program. The Concierge Program is advertised on business cards, websites, 8x10 sheets of paper that they hand out. And it indicates that the Concierge Program is unlicensed individuals who are interacting with the consumer providing certain services. In that, we interviewed the people at the funeral home and also obtained what the family provided us as job descriptions. Our concern became in those job descriptions which you have attached. It indicates to the employee that they are never to make funeral arrangements solo, serve only as an assistant to the licensed director present during arrangements, and never perform an embalming solo, but to serve as an assistant to the licensed embalmer present during embalming. Our concern with that is that the law does not allow for an unlicensed person to be in the embalming room without being authorized, or unless they are particularly, if they are assisting, they must be an apprentice, and neither of these individuals will qualify for apprenticeship. We did pull death certificates for this funeral home during the time that the complainant states that she was aware that this program was put in place in the current, and we looked at 10% of those death certificates and contacted those families, out of all of them, except for 2. They were very happy with the services and had met with the funeral director who was licensed. Only 2 of them indicated that the person they spoke to was one of these concierge.
To make funeral arrangements or just to interact?
The first family had an individual who died, it's listed as number 1, October 26, 2014, and this was shortly after this concierge program was put in place. And I spoke to 2 family members who made the arrangements. Both are willing to testify and be witnesses as well. Both state that they met with a lady, and the licensed funeral director was not present, and the individual they identified as a lady was one of the ones on the business card which had blocked out their face, but they've identified that as the person. The other family, we spoke to, just one family member was the only one who made the arrangements, and they state that all arrangements, forms, and costs were made with one of the unlicensed individuals, but that she did see the funeral director, but did not discuss anything related to the funeral. But the first family didn't see that the funeral director when we identified him. In this case, you can see the business cards attached. This funeral home has business cards with pictures on them for all of the individuals. And so we utilized those in interviewing the families and to be able to identify who they met with.
And our order is for them to stop doing these services?
Well, our recommendation was for the board to consider a motion for me to direct me to issue a cease and desist notice to the funeral home and funeral director regarding the use of unlicensed individuals identified as funeral service concierge and funeral director assistants specifically for identifying unlicensed individuals titled as funeral service concierge or funeral director assistants and indicating they can make funeral arrangements and perform embalming as an assistant to an unlicensed funeral director.
Discussion?
Well, Mr. Chairman, not as formal as this is. Over the last year or so, I've been just hearing from different people across the state where, not colleagues, but families, that this is happening in a lot of funerals. These unlicensed, people are getting involved. And I think we really should take a stand on something like this. It diminishes our the license. I mean, and these people, we basically, as a board, as regulators, have very little control over them because we don't license them. And I think this is becoming more and more of a problem of these unlicensed folks getting involved in funeral arrangements.
Mr. Chairman, I make a motion to order the executive director to issue a cease and desist notice.
Second.
Any further discussion? Motion on the floor. Let's do a roll call vote, please.
Mr. Cannon?
Yes.
Mr. Boyer?
Yes.
Mr. Fleming?
Yes.
Ms. Betzer?
Yes.
Mr. Wassler?
Yes.
Item 6.04, recommendations to close.
There are several cases for your consideration. The first case ends in number 45. In this case, we received a complaint about false and deceptive advertising. And in previous cases, you closed the case if the funeral home was made aware of it and immediately corrected all issues, and in this case, they did. The second case is ending in 49, and this was a complaint for failure to obtain a burial permit prior to the removal from state. Our investigation determined that the burial permit was obtained in a reasonable time frame. The burial permit was obtained within the proper time from his days from the day of death. And the only reason why it was not obtained until 24 hours later was that EDRS was down. So the next day when EDRS was available, it was obtained quickly. The next case is ending in 5-1. This was a complaint about the deceased was cremated without the consent of the biological children. And our investigation actually determined that the deceased was actually not cremated at the time the complaint was even filed, and was not actually cremated until most recently. The biological children were properly notified of the death of the father, and by not only the funeral director, but the funeral home's attorney as well. And as of March 11, the children had continued to fail to exercise their right of disposition, and the funeral director had moved on down through all of the right of disposition until he became the legal person to actually make that determination himself. And in case ending in 53, this was a manager, actually the next two, 53 and 55, are both a manager or an AIC who actually failed to renew their license because the law requires that should they not be able to perform those duties, that a replacement need immediately. But the issue was immediately corrected with those individuals renewing as soon as they were made aware of the notice. So we're recommending to close those as well.
Mr. Chairman,
You also
I make a motion to close.
Second.
Any discussion on these 5 or 6 cases? Roll call vote, please.
Ms. Betzer?
Yes.
Mr. Boyer?
Yes.
Mr. Wasco?
Yes.
Mr. Fleming?
Yes.
Mr. Cannon?
Yes.
Motion passes.
Item 6.05, pending cases.
We are currently still investigating all of these cases. There's probably not all the detail I can provide since they are pending investigations.
Does anyone have any questions on
just noticing that there are a few of misappropriations of pre-need.
Yes, there are. In one of the cases, I can just say is one of the acknowledgements is already expended.
One is already.
Yes.
Does anyone have any further questions for Vanessa regarding these pending cases? No motion needed for that at this point. Item 6.07.
I currently have 3 cases that the board has taken order on that are pending with me. One is, since the last meeting, the Walter Piper case specifically associated to Walter Piper Jr. only in the case, not the other individuals that are in the case as well. And that is pending the settlement agreement that was authorized at the last board meeting. And then I have also the Carino and the House of Wills. They're currently with me. We have made notice of the order from the board, which in both cases came back. We certified, mailed it, and it was recent certificate of mailing.
And those two are in Mark Myers' team, right?
No, they're with me. We first have to allow them an opportunity to request a hearing.
Any other comment on these?
Well, we're gonna start sending stuff just regular mail besides the certified mail. I know that was one discussion they had out of, when we went to the Carter class. They were saying some agencies are starting to send things not only certified, but also by regular mail. I don't know if that's something we should consider.
If, in this case, if it's an order of the board, we need to get notice back that they've actually received it. So if I send it regular mail, they may actually receive it, but it doesn't do us any good. So I have to send them a certificate of mailing and get an actual green card back that shows somebody signed for it. And in a lot of these cases, people don't want to sign for the document.
Right.
So then we send a certificate of mailing, which allows us to show that the post office certifies to us that they mailed it. If we get that back, which in some cases we do, we then have to hand deliver them, so I have to actually dispatch an inspector to serve them. So we can send them regular mail as well, but in many of these cases, people understand that the order is coming and their intent is to avoid it.
Right, right.
Other questions? Or do you have other comments on any of these?
No.
I think that most of us saw the email that Summer sent us yesterday regarding these pieces.
I had time to look at it yesterday, but I didn't read that.
No motion is needed on 6.07. Item 7.01.
If it's okay with the board, I would bring the legislation and the drafts up here and we can work on it from here, is that okay?
Sure.
Kit Kats and Reese's. We had some vanilla ice cream. I know, I requested
What 701 is recommended legislation for consideration. Why don't you go ahead and
What I've tried to do here is incorporate all of the conversations that we've had, probably over the last year at least. And some of these things we have made attempts on in the past, but I'm including them back in the draft legislation again for you to consider whether you want to make another attempt on them. The first item, though, is just updating the definition of funeral directing to include from one or more funeral homes licensed under this chapter. It is mentioned that way in other sections of the code, but not in the definition. So that is just making them more consistent. I'm trying to figure out these things are different. Another thing that we've talked about is actually issuing a permit type license to crematory operators and to require that the crematory operators have a certificate of completion from an accredited program to obtain that crematory operator permit, and that those crematory operators then be AICs for the crematories. So in this case, we would change the definition that used to say an operator of a crematory facility to a crematory operator and define it as it being an individual who is actually obtaining a license under this chapter.
So basically, that's another housekeeping.
There's going to be a lot of things we'll have to change as we add in the crematory operator permit once we change that definition.
I think you've got that all the way through.
Yeah, we're going to see that all the way through. So I was telling you that's a piece of it. Next, in 471702, this is defining reward. One of the topics that has come up in the past would be to add language that was consistent with several other boards, which allows a member to stay in their position until its successor is named.
Some other states have that option or something.
Yes, some of the boards in Ohio do as well. So is that, any questions about that one? Organization of the board, this is mostly a housekeeping. We've talked in the past that we call our secretary treasurer that right now, but the treasurer is probably not a term that is appropriate at this point because you actually want any seals to the board or to the licenses more actually attesting to the funds. So it's just removing the title treasurer and then removing the piece that says that will fix the seal to each license. Other items that we discussed is the crematory review board. The crematory review board is in our statute. It requires an issue regarding a crematory to go first to the crematory review board, which is 3 members of our board that consists of our president and other members appointed by our board, and members of the cemetery board. I am the executive director of the crematory review board as well. They hear the case and then make a recommendation back to your board, which is mostly yourselves as well, and we were looking, and this is more of a compensation initiative, and we've been eliminating one of the layers in the process. So this is removing the crematory review board.
And in my 8 years or so on the board, we've met once a year and have had nothing before us.
And maybe 10-minute meeting.
Yeah.
A roll call.
What I perceive potentially happening is, as you're aware, cremation rates in Ohio are on the rise, and we expect by 2023 that that'll be the break even, where there'll be more cremations than regular burials in Ohio. At that point, you may have more issues around crematories because in just 3 years' time, the number of crematories you had went from 116 to 135, so they are on the rise as well. So as you start addressing issues with crematories, you had a two-step process and a very different type of process than you do with everything else. So we'll see this throughout where it's mentioned, and this is just striking it completely. By striking it, it would, crematories and crematory operators both would follow the same process as any other licensee and the report. Also, the leaders cleanups, this is just adding in the word permits and crematories into these areas. This is also the crematory review board. And this is just housekeeping as well, adding in licensees and permit holders. This section has been stricken in the past for other boards. This is prior to there being a biennial budgeting process. So when our board was originally created in 1902, this piece was put in that it required our board to give a report each July to the governor's office of our expenditures, but that's actually handled through the Office of Budget and Management now as part of their function. But again, just a striking crematory review board. Then license qualifications, 471705A2, it would be adding specifically that for the applicant has pled guilty to or has been found by a judge or jury to be guilty of a felony, or, and it goes on as it used to read.
So what was there before?
Exactly what is all in black.
So the word felony was never in there?
It was not there. We also discussed that, and what brought this discussion up, as we'll see later on in our language, there was revisions in September, I believe, of 13 that allowed a funeral home to sell their funeral home and to make application, and for the new funeral home to make application, and for the new funeral home to operate under that application without any approval of the board until the board denied the application. And the board discussed that what they would prefer to move to is a discretionary process by the executive director and that it being ratified by the board. We also talked about doing that for licensees because any of those that become eligible tomorrow for licensure would actually have to wait until your next board meeting to be considered for licensure. And as long as all items were in order and there was no concerns with the application, this would allow me as executive director to issue a temporary license until the board met and was able to consider the formal application. So we'll see that throughout here where it talks about licensing individuals and funeral homes. And that is the same thing again here. This one is specifically for funeral directors and those embalmers. And item number 3 here, this is a cleanup. In our language, it said the funeral director embalmer can pay a reactivation fee to the board, and it listed our old licensing fee at $140. And our fees are actually defined in section 471707A1. So we're being consistent by just taking out the specific amount here and referencing the section of code in case the fees are ever updated in the future. They're only updated in one place instead of multiples. Another thing that some other boards have moved to, our board, particularly in our fees, it talks to that the fee is for the issuance of a license, which means that should the board not issue the license, we need to return the funds to the individual who made the application. So we would have performed those services of processing the application for free. But more so, the other concern is that by law, when we receive an individual's check, or our firm's check, we have to deposit it within 48 hours or send it back. So when we deposit those checks, which we would with the application to begin the processing, it goes into the or K-9 fund, or a K-9 fund. When we have to return the money, we have to, I guess what I'd say, eat the appropriation on those funds. So each check you return, you reduce the amount that you can actually spend for your regular operating expenses by that same amount. So by changing all of it to be a fee or an application fee, we would retain the funds for processing and doing the work that we do, whether a license is issued or not. This is starting in, well, we have talked about that Pennsylvania has been sued and lost on their naming requirements. Ours mirror their naming requirements. And so we've talked about removing the specifics to naming and going in a different direction. So what we are saying here is that upon the filing of an application for a new funeral home license, I could issue a temporary upon the consideration of the board, but the need of it is here. We would say that a funeral home shall be operated by a person who is the holder of a funeral director's license issued by the board, whose name is the actually in charge of and ultimately responsible for the funeral home. The licensed individual who is actually in charge of and ultimately responsible for the funeral home is the owner of the funeral home license. Now that's listed in several other places, and we're striking it and moving it together. The funeral home shall have, so instead of the naming requirements we have now, shall have conspicuously displayed at its main entrance utilized by the public the name of the licensed person who is actually in charge of and also responsible for the funeral home, and all names of persons and or corporations holding ownership in the funeral home. Each name shall indicate that the individual is licensed by the board. Failure to make full and complete disclosure of the name of the licensed person who is actually in charge and ultimately responsible for the funeral home, and all names of persons and or corporations holding ownership in the funeral home to the board and the public shall be grounds for the revocation of the funeral home license.
Yeah, question on 2 there. Should that say funeral home shall be operated by a person or a corporation?
No, this is specifically who's named as the actually in charge and ultimately responsible. So this is a person who is the holder of a funeral director's license issued by the board who is named as the AIC as we refer to them.
Okay.
So if it's not in the sign, it needs to be on the plaque on the board. I know they kind of state that, all owners.
Yeah, and this.
But would that actually hold up? Because no other business has, in the state of Ohio, has to push the owner by the door. So would that actually, could it be upheld? Because no other business has to say who.
It's
Like when you have Walmart, we know the Walton family owns Walmart, but just because of the news. I'm just saying, because if you had multiple people being owners and all that, I'm just saying, will we go for one thing that's not being upheld by a Supreme Court or a court, and then going to something else that states your name has to be there?
There are many other states that have multiple different license types. If it is not owned and operated by the same individual, requires it to be made available at the entrance to consumers so that they understand who they're interacting with for the safety of the public. I have not researched other licensing boards in Ohio to look for this exact language. I looked for this exact language and got it from other funeral licensing boards throughout the state to see how they did it, how they did it out the country, and to see how they did it without the naming restrictions that we have.
Because I know anybody working there, you have your license hanging in a preparation room, staying there in a Embalmer, or you have your license.
You still
where
have that. All
that
of
is
those-
hanging there. I just,
Okay,
some
so
may be awfully long.
I'm using mine as an example. My facility is owned by trust. So are you saying that we have to put the name of the trust?
Yes, it would say, who is your AIC yourself and Jackie?
Uh-huh.
So it would, at the entrance of the facility, indicate that Robert Wasco and Jackie Wasco, licensed provide and whatever the LLC or corporation name is.
Also family trust.
So I don't know if I'm in favor or something like that.
I think that's gonna be an issue that.
I'm just saying it's gonna create another illegal battle. There's no other business that has to say who owns it, no corporation, your dentist office, your optometrist. It might be great long optometrist, but you come in, there's 4 or 5 people working.
This is changing the whole complex. You know, that's what we have now. Which what we have now is not real.
It's not efficient.
Stable.
No, I agree.
Which is just me, so it'd be just me on the sign, so I'm just thinking other people or other businesses.
What would you like?
Well, I'm not even prepared. I just think there'll be enough debate on this, I think, as we go forward.
There, you know, this was previously discussed even with the Funeral Directors Association, and there was debate there as well.
Right.
But there was no other alternative or version that anybody came up with.
But if your business is incorporated, okay.
And that's on file with the state, as do the others.
Yeah.
Other concerns, like in the industry,
But Greg, so we're allowing, this is almost gonna be like going into the Wild Wild West. So a person's gonna be allowed to name their facility funeral service. Okay, so the public has to be, I think, be aware of who has that license that owns funeral service.
But if you look up at the state records, you'll see that. You'll see who's actually in charge of.
But the public doesn't know that. They're not going to go to the state records. They don't know this, you know. That's why they're saying the owner's name should be by the entrance.
But if you go to a ballgame, it doesn't matter to you who really owns the building if you're watching the game then.
Well, yeah, I think we're a little bit upset.
I know, I'm just throwing something out there.
I mean, we're dealing with pre-need trust, we're dealing with a lot of, you know.
Right. I just don't know the legalities of it, so that would be more my concern. Is it going to be something that's going to be contested later?
I'm sure we'll get
I'm sure.
opposition.
We'll be debating this for a while. This is just starting point.
Because we can have the Wild Wild West or create the Wild Wild West.
This was a lot of the discussion was at that round table over the OTA office that day.
Right, and that's what I heard.
And this came up for discussion because we knew that we were in the same position as Pennsylvania. And so we were trying to come up with a resolution before we had that scenario as well. So we would lose because.
See, I got my
That's what you already lost.
So by my door, I got my no smoking sign, whether you can carry a concealed weapon, whether it's a handicap sign, and now I got another sign. I just feel it's confusing, which.
No, they know we're frustrated.
I know, but what? It's just a lot of signage.
This is all, you know, obviously she's imposed this suggested change, so I mean, it's all in discussion.
The other thing that we do not have, but most other licensing boards do, is a piece in our statute which says that allows the board that if a person's license is revoked under their chapter, so we revoked, for instance, a funeral director's license, then they shall not operate either directly or indirectly or hold any interest in a funeral home. Perfect scenario would be if you had gone through the process to revoke an individual's funeral director's license for misappropriation pre-need, they could make application to become an unlicensed owner of a funeral home. And this would eliminate that. It would be clear that they could not. Right now, a crematory and an embalming facility have to submit new application to the board should they want to change who they're actually in charge is or any other pieces of their application, and requires them to make a new application fee and go through the process of getting the board's approval done. But right now, funeral homes have the ability to do certain things through an amendment. What we have noticed over the years is that the board gives very careful consideration to the application, makes a determination, and then within days of the board's approval, the funeral home makes amendments to that application that maybe the board may not have approved the application had those been presented. So this is making them consistent and doing away with that amendment process. The only thing that can be done through amendment would be a change of address for a specific individual. So if somebody is updating their address, but changing the AIC would require a new funeral home application as well. This is the same language that you saw for the funeral home, but this makes an embalming facility. And then we'll have the same thing going in down for a crematory facility. So it makes the three of them consistent. Just adding permit to 0601. And when we go to 0.07, we're looking at fees, and we're changing those to those being application fees. Also adding in some information for crematory operator, because it doesn't exist now. Making them consistent. We have a maximum reinstatement of $1,000 per license on other license types. We did not have it on these, so it's just making those consistent as well. We also have talked and pursued a pre-need fund. So adding into the fees here would be a fee for the recording of each pre-need funeral contract sold in the state of $10. And the pre-need fund information will be at the very end. Also just adding in permits to renewals. In continuing education, the first green piece here is just being moved. We thought it made more sense here, so it's just being pulled and moved. We are adding in language about courtesy card permit holders. Right now it's not included in our CE, which is just clean up, making clear that courtesy card permit holders don't have to get CE. And then adding in a crematory operator permit, we have to add in their CE requirement. We are proposing to not have a waiver or an exemption. We are proposing changing the CE language for it to be an exemption, and stating that any licensee who has 50 years or illness or disability, or is not practicing funeral directly, or not has limited engagement in practice of funeral directing and embalming, and they are not actually an AIC, then they could make the application to the board for an exemption. Any questions about those? We changed nothing with reciprocity of courtesy cards. And this currently is just usually known as the change of location or ownership, which allows them to do amendments. This would be changing it for a new application if it was an ownership. So this is saying that if there's a change of location, AIC, statutory designated agent for ownership, that you will be able to reconsider the application. And so then in prohibited conduct, we are taking from the administrative code and placing into the revised code the same sentence that was the refuse to prompt us into the custody of a dead human body, and we're also adding in for clarification or cremated remains upon the express oral or written order of the board legally entitled to the body or cremated remains. Disciplinary actions. Currently, when the board charges for misappropriation of pre-need, they've charged under 4717.14A4, which is unprofessional conduct, then cited the administrative code for unprofessional conduct, which includes misappropriation of pre-need. What we are proposing here is to take those sections of code right here, which are 31 through 38, and rules adopted under those sections specifically place them right in A3. And this is mostly also to, we would charge under that, as we've done it with prosecutors, but make it clearer to them that those specific sections were listed here as prohibited acts. In this case, we were just changing it to say that license or permits include all of those issued by the board. Next one was a crematory review board piece. This is clean up about permit. This is crematory review board. Clean up again about the types of licenses. Crematory review board. Authorization form is change. Currently, the law actually says by sending to the operator via facsimile. That's a bit outdated information. As long as they receive what is in the rest of it, the intent stays the same. So we're just striking the facsimile transmission as part of the requirement. Disposing of cremated remains. Currently, the law only allows a funeral home to dispose of cremated remains if they have not been claimed after a 60-day period by placing them in a grave, crypt, or niche. We're proposing the addition of or by scattering in a dignified manner, such as memorial garden at sea or by air. And keep in mind, some of these things would also still require other approvals or approvals to use.
A question. At sea, what about a lake?
Well, that's, I think, and Vanessa and I had some discussion on this, but you gotta define what lawful manner is. Is that what you're at?
Mm-hmm.
Yes. That's, because it really does not have a definition.
We scattered by air on our farm.
Other permissible acts that anybody would do is scatter them on their own private property. But if the funeral home is scattered on any property that was not necessarily their own, such as a memorial garden, they would have to have permission from the person to be doing that as well.
Mr. Chairman, may I ask a question just for my own education? Recently, I was asked by somebody whether or not they could pick up the cremains, ashes, whatever, and scatter them. And I said, well, I said, we better check with the funeral, the executive director of the funeral home. I don't know whether or not there are any restrictions. Are there restrictions on how someone can scatter ashes?
For a family member to pick up their loved one, they could scatter, it depends on where they want to scatter them. If they're willing to take them to a state park, they would have to get permission from the property owners from the state park to do that. If they're willing to scatter them on their own private residence and they own the residence, they can do that. I have gotten a question in the past recently, they wanted to scatter them on their property, but they were renting the residence. So they need to have permission from the property owner. If they want to scatter them by air or by sea, there's no permit required by air as long as they don't release the container, of course. That's what the stipulations are. By sea, if there are limitations, it has to be 3 nautical miles from shore.
So you couldn't go to the bank of a river here in town and dump them into that river?
Not by the law requires it to be 3 nautical miles from shore.
Isn't it though, like,
You want over there?
Lake Erie, for example, or they can scatter in a lake. State park is also just public property. Can't be scattered in state park.
Law just says they need permission,
So,
that they need permission. But, you know, this particular proposal is focused to what funeral directors and funeral homes can do. And so we put, and such as, but we were trying to say, scattering in a dignified manner, such as, we listed things that they would potentially not need approval from an owner. A funeral home could get permission to scatter them at sea.
what about changing that word from lawful to dignified?
We don't have lawful in it.
What's in red? Why, I guess I want to see it.
Oh, did you press something for something old?
No.
Oh, this is, well, that was when you met with me.
Right,
We changed the defined law.
okay.
Here's what we've got up here. So it now says,
You already had.
yeah, an
Okay,
engraved
sorry.
print, niche, or by scattering in any dignified manner such as.
Because they're even taking concrete, making molds and putting the cremains in there and starting burgers to the oceans.
At one point, we talked about it saying in any lawful manner. The concern with that is that it is lawful, although I may not do it, it is lawful for me as a family member, if I so wanted to put my loved one's remains in the trash. I could lawfully do that, but we did not want to say that that was a dignified manner for a funeral home. Is there anything we can add into this piece, or are we okay with this piece? Get them to Greg, Greg will fly them. I'm talking about this piece right here where it says, this is just updating for crematory operator permit, making language more consistent. This is the sellers of who may sell certain pre-need funeral contracts. Currently, the law talks about an insurance agent licensed pursuant to Chapter 3905 may sell, solicit, or negotiate the sale of an insurance policy or annuity that will be used to fund a pre-funeral contract, but in so doing, the insurance agent may not offer advice or make recommendations about funeral services and may not discuss the advantages or disadvantages of any funeral service. But then it says that in selling or soliciting or negotiating the sale, it goes on to list those things that they can do, which it appears that they, in this paragraph, say they can't do. So it's proposed to strike those pieces leading the paragraph. Part of the concern where this also ties into the misappropriation of premium is that these licensed insurance agents many times are not at a funeral home facility. They are not someone that we regulate, and they are a lot of times assigning policies then to a funeral home. And we do have a case where the funeral home was the entity that the consumer made the complaint against, that's about misappropriation of pre-need for us to find out that the funeral home's not even aware of that because it is actually this. It's an insurance agent. So we are continuing to investigate that, but in that case, the insurance agent did use a worksheet, did use general price lists, and all of those things gave that consumer the determination that they were actually dealing with the funeral home, but they were not.
Whereas this person was not even affiliated with the funeral home.
Not at this point, no. And so in looking at what the black language says compared to the red, it does seem to, in some cases, contradict itself. And this is something that's been discussed back and forth for some time, whether to keep the red language, to change the red language, or to strike the red language.
So this will help, this will take out the contradiction between the two by taking the red out?
It could, yes. It would still allow an insurance agent to sell, solicit, and negotiate the sale of an insurance policy. But they will not be able to make recommendations about funeral services, and they will not be able to discuss advantages or disadvantages of a specific funeral service.
I really don't know how that does not happen. Oh, do we have that all the time?
Have a question?
I have a comment that soliciting the funeral services does constitute funeral directing. You can't delegate that to non-licensed individuals.
Say that one more.
The soliciting of funeral services does constitute funeral directing, in which I, as a licensee, am prohibited from delegating that duty to an unlicensed person. So if I'm delegating that to a non-licensed person, I'm knowingly letting them engage in the unlicensed practice.
Well, to me, by striking this paragraph, that pretty specifically says what they can do. So
Right.
as the unlicensed
They can
person,
only solicit the sale of an insurance policy.
that's not contradicting. So that it's.
Because when you watch the TV ad, it says the average cost of a funeral is X number of dollars. So if you purchase this amount of insurance, it should cover. And that's on TV, tracking every day.
That type of language would still fit in with that time.
But they're not giving advice, they're just stating that's the national average.
This also adds in to pre-needs, that the seller of a pre-need funeral contract would also have to include the fee for each pre-need funeral contract sold under, as required per the section of code for fees. This is adding a disclosure.
What disclosure?
Yeah, adding this, we were going to discuss about adding a disclosure about the fund, but we first have to figure out how the fund is going to be moving, and this would be a disclosure to the funeral.
The disclosure of the pre-need.
Fund.
Gotcha.
Yeah. So this is just a place mark to say we would also want to make sure that on those pre-need documents, there was a disclosure about the fund.
Gotcha.
But we'll put that in once we get it completed. In 47-17-35, talking about selling a pre-funeral contract by insurance, this is changing and requiring the fees to be paid directly to the insurance company.
We're not addressing payments to trusts.
It's in another section of code. This is trust, so this is changing it, that where it allows them within 30 days, taking that out and having the funds directly to the trust.
Okay. So basically, the funeral home cannot receive any funds for any pre-needs, no matter if it's trust or insurance.
Correct. But those funds will be paid directly. I think that was one of Mr. Boyer's, he would like to have Adam liabilities.
Just, that's, we're gonna get some, I think we'll be okay with the insurance aspect of it. The trust aspect is where we're gonna have some opposition.
And a lot of discussion with licensees, their only concern was being able to write a second check for the taxes that need to be paid on it. And those taxes aren't associated to the trust anyway. So they would have a consumer write one check to the trust and one check just for the tax amount. And that would still be compliant with this because the piece that was supposed to go to the trust was paid directly to the trust. This is the crematory operator permit qualifications. So this is adding in that license and adding in the qualifications. One of the questions I have here though is right in here where we talk about that they would need to satisfactorily complete a crematory operator certification program approved by the board. The question is what types, if we went this direction, what types of programs would you approve? Because there are CAN, there is NFDA, and then there are vendors who also offer certification programs. But they're very different in their content and in the number of hours and what they cover. So by putting it this way that's to be approved by the board would mean that we can set a rule later that spells that out about that application process to get approved. But you probably want to start thinking about, before we ever go that direction, what you think you would be favorable and not. So there's more consistency between the type of certification that a crematory operator will hold.
I think, and you may too, as crematory, you know crematory? As crematory owners, I think, and I've seen a couple of different programs and certifications, they all relatively have the same stuff in them, you know. Now, a lot of times if it's done by a manufacturer, it's, you know, leaning more towards their machine, you know. But as long as we have an approved program or something of that nature, I don't think we have to specify, you know, which program.
Well, yeah, here we weren't. Here we were just saying that it would be a program approved by the board.
Exactly.
And then we would put in rule an ability to get that program approved, just like you do in your other CE program. But it's just starting the discussion of when you actually get an application for one, what are you expecting to see, so we can help people understand how to develop those programs. Because there will be other entities that will come in and play that they want to develop a program to do this that don't currently even provide it. So that's just an item for future discussion.
Mr. Chairman, the age requirement of 18, is that consistent with this whole section?
It's consistent with your other licenses for an embalmer or funeral director.
I just don't know how that happens.
How will they become a crematory operator?
Or no, a funeral director.
I don't believe they do. I think they meet all of the requirements. If for some reason they were a Dookie Howser of the funeral industry, they possibly could.
Well, great.
But each one of them, each one of the licenses start out with one, which is that exact same sentence that they have to be at least 18 years of age with good moral character. So if somehow they meet all the other requirements and are younger than 18, they still would not meet the requirements. And this is the pre-need recovery fund. This is the proposed language that Mr. Roscoe loves dearly. but this would establish the pre-need recovery fund, and it would be administered by the board. The purpose of the fund is to reimburse purchasers of pre-need funeral contracts who have suffered financial loss as a result of the malfeasance, or default, failure, insolvency in connection with the sale of a pre-need funeral contract by any licensee in this chapter. It goes on to spell out how the fees will be deposited, what the fees may be used for.
I haven't seen that part of it yet. Obviously, you had since you gave me this copy, but is there limits on that too? As far as what the reimbursement is?
It's determined by the board.
Just determination.
I'm sorry, the fee will be determined by the board?
The limits on the payout, I think we're talking about.
Okay. Who determines the fee?
The fee was established in '07 as $10 per contract sold.
Do we know approximately how many contracts are sold a year?
Not a year, because they're only required to each year provide us a sum of all of the contracts they now have as of December 31st of the prior year. So in that time period, many people pass away and many new ones are sold. So we don't have a way to compare the two pre-need reports from year A to B to see which ones necessarily are new, because individuals could have been sold a contract in that year and passed away and not have been listed on the report.
By any interest.
OFTA had some sort of estimate, what they believed was a yearly contract sale, and I don't remember.
But that was based off the trust, not the insurance.
So it was based off of just their individual.
Just their trust. Because they were able to say what new ones were done on the trust with.
Yeah.
They had insurance number. And that concludes it. Now, just a reminder that none of these options will prohibit or keep someone from misappropriating pre-need. If they're going to do that, they will still do it. But by having the funds directly deposited and not commingled, will make it much easier for us to find it and for it to be clearly intentional. Because in some cases, we have spent a lot of time figuring out exactly when they received the money and when that 30-day mark was, and was it, we have to prove intent to, and was it an oversight, an accounting oversight, was it an employee oversight, what caused that misappropriation of pre-need. So in this case, by adding that direct deposit, there should never be any commingling of funds, which makes it much easier for us to show that misappropriation and to work with the county prosecutors to get these prosecuted. The fund won't keep someone from misappropriating, but it will help the victims after.
It may come down to the more the public is aware of that too, but obviously, just like Vanessa said, anybody that's going to commit fraud will do it anyway, one way or another.
So I have a question. If my pre-need is $10,000 and they're going to write a check to XYZ insurance company as a direct deposit, then a separate check for $10 is directed to the Board of Embalmers and Funeral Directors?
The fee is from the funeral home or funeral director who sold it. So the consumer would pay $10,000 directly to the trust, and then once, the requirement is that once a year, you would have to make a check out for each one of those that were sold in that year at $10 each.
So XYZ Funeral Home makes a check out to the Board of Embalmers and Funeral Directors for $2,300.
Correct. And that $2,300 is then deposited in the fund, and then you may be able to use things items or to be.
There's nothing to say though that you can't charge for that. If you want to make it $10,010, you're going to take $10 out. You're trying to see you can charge for this. Right. Are you finished with 7.01?
If there's no other questions, I'll shut this down and get back together.
Well, actually, if there's no questions, I think we need to take a rest break.
Okay.
Kathy has a question.
Well, I think it sounds unfair to charge the person buying the cremate that $10, when it's the malfeasance or misfeasance of the funeral director, that money is covered.
I don't disagree with you, I'm just saying.
I'm commenting, it's.
No, I'm the one that said it, I'm just saying that,
That's right.
yeah, you have the right to charge for it if you want to.
Well, it's not fair.
Well, also, if there's a shortfall, then the trust may pick up that shortfall. If the casket prices went up, the ball prices went up, so the consumer, actually, if there was a shortfall, could benefit from paying that $10. But I'm not saying that the consumer should have to pay it. I'm not saying that. If there's a commission off the insurance policy, I'm sure the insurance agent could pay that commission.
Insurance, if an insurance agent sells a cremate, does he have to pay the $10 also, or is that just funerals?
The fee is for all contracts, so all cremate contracts, not associated to just trust or insurance.
Now, I understand too, we don't have control over a lot of those people that are out in the field doing it that aren't even associated with it.
I recall someone from Indiana talking about this, and they collected this money until they had gotten X thousands of dollars in, and then they didn't collect it until they drew it down and then started collecting it again.
I think it had gone up to what, 2-3 million?
Yeah.
And then they quit collecting the
Right.
fund, but the fund had stayed there.
I don't know, but we're not doing that here.
No, in this one, what we're proposing is that the board would collect it until the board determined that they had sufficient funds in, and then they would cease the collection and we could implement it back into the rate.
Mr. Caniff, when a lawyer misbehaves and appropriates his client's funds, what fund reimburses the client?
There's a victims of crime compensation fund, but I don't know whether.
That's for violent crime.
Pardon?
That's for violent crime.
Yeah, I don't know that there is a fund when a lawyer misappropriates money
The
from.
one the Supreme Court runs? Supreme Court runs a fund.
I don't think so.
And it's in our fee, our license fee that we pay.
Well, I think that's accurate because in my community, there was an attorney who had some problems with his escrow, I think, and he actually drained the fund that the Supreme Court had. Is that?
I talked to the Supreme Court about this, and it's all funded by the miscreants. That is, lawyers, that class of miscreants, lawyers. What you're doing on this deal is you're putting the burden on the victims. So you're going to charge your victims extra money rather than charging the funeral directors the money.
No, that could be done either way. I'm just saying there's nothing to say if this funeral director chooses to charge that client $10, you can. But whereas probably most cases, we're just going to pay the $10, you know.
Yeah, I think this takes care of maybe part of the problem by having that check written out directly.
Oh, yeah.
Takes care of part of the problem if the rules are followed. However, if you want to tax the miscreants, then raise your license fees and put that extra chunk of money into the victim's compensation fund. Funeral directors are the ones who are stealing the money. Funeral directors should pay the victims, just like the lawyers do. It's in our fee.
Real estate has a similar type of recovery fund if you're damaged by a real estate agent.
And who funds it?
Apply. I'm not for sure, but I believe it does come from licensing.
Yeah. That's what it should do. And I'm wondering, you know, you got an extra $10 fee here that the public is going to be charged. I wonder what the governor's office, Mr. No Tax Kasich, is going to think about that.
I just want to make sure what I have drafted does not say that the consumer pays that fee. It says that the funeral home
Right,
has
but
to
in
submit
reality,
that.
what's going to happen is it's going to get passed on.
Well, it's the same for anything, though. I think it's going to get passed on no matter what. Whether your fee goes up, whether your costs go up, that's still going to get passed on.
I increase my service charge by $10.
or within the
So in essence,
funeral
you're
home,
legislating
it's
that
passed on.
$10 tax.
And I have presented similar language to do a fund for victims in the past, and have been told no fund.
Because it was considered a hidden tax on the business, on the
Because
industry.
there was no agreed upon method of how to fund it. There was, at one point we discussed that it be added to a death certificate, but that was a tax on a consumer. At one point we talked about we did talk about adding it to licensing fees, but that would be, again, talked about being passed on to consumers and prices would be increased. We talked about this version, which was, it's $10 per one, and that's the last one we left it with. But in all of the versions, no one felt comfortable with how the fund would be, how that revenue would be generated, and where it would come from. And then there was also concern that it not actually resolve the issue, which was the misappropriation of premium, but that it would assist those victims. We also at one point talked about even bonding, licensees. But that was, we quickly looked into that, determined that if this was intentional, that the bond would necessarily be what fixed that issue.
Well, the funeral home paying per contract will at least get our arms around how many contracts are sold, for that particular year. Hopefully.
And then also on the death certificates, they're $25 per because the money collected by the Board of Health pays into a fund. And one of them is it for children and battered women, where the death certificate money is paid to?
It's not the death certificate, it's the burial permit.
I thought where it came out of the price of the death certificate, that is their reasoning behind charging $25.
I think he's right, because the burial permit half goes to the local registrar,
Right.
half comes to the
The
state.
death certificate pays the fund, the certain bill's $27.
Only 50 cents goes to the state for the cemetery resolution board.
There's two funds that come out of the death certificate.
All right, any further discussion on 7.01? If not, I'd like to go for a 10-minute restroom break. So let's be back here at 25 till. 25 till. Reconvene our meeting, so.
I had a question, Linda. How much was it, like, part of your license, how much was when?
I don't know what the dollar amount was, but I know our licensing fees have gone up tremendously in recent years. And that's because I think now there's more funeral directors in jail than there are lawyers, to tell you the truth. But it's because there was a lot more fraud, especially in our recession times, and as we become overloaded with lawyers.
Do you know that number? You're fairly new into the business.
No, I don't know how much I actually knew there was recovered.
She's also not in private practice, so she's probably not going to be sensitive to that issue. Hey,
I'm in the federal government, so I had to pay my own license fee every year. I knew that was going up.
I've been in
part of that
business.
was funding crime victims, lawyers' victims, which I had nothing to do with. It's real hard to defraud the FBI.
Linda, I've been in the business 30 years and I don't know the answer to your question.
Yeah, well, that's why I called the Supreme Court several months ago when it was proposed here that the fee be assessed on the consumer. Because like Kathy says, that's really not fair. It's not the consumer that's the miscreant. Lawyers fund, their Supreme Court fund, the violent crime victim fund that we were talking about is funded by fines and assessments on criminals when they're convicted. And now we got another board that does it the same way.
Any way around, whether it's the attorneys or the funeral directors, it's going to go back to the clients, because if your license fees go up $300 a year, well, I got a little bit more of my hourly wages, you know, whatever. So it's all gonna go back one way or another. That's how we're all in business.
But you can keep track of it.
Yes, you can
And
have
that's
record.
how you keep track of it by saying, hey, you haven't renewed your fee, your license is over,
Right.
send in your money. And then we know,
Well, that way you can't keep track of that way.
We know though that we will also, if that's where the board wants to go with it, we absolutely can. But we know we will get resistance from the association because they did not want people who do not sell pre-need to have to pay into the pre-need fund. So they wanted only those that engage in that process having to pay for it.
you're talking about consumers or funeral directors?
Because the association was concerned that not all funeral directors have to pay a fee if not all funeral directors engage in selling pre-need or sell pre-need. They only want.
I had to pay a fee, and I was a government employee who couldn't defraud anybody.
I'm only
Well,
letting you know
it would
what's
be to the
What's the thing
advantage,
about that?
it would be the advantage of the funeral director to pay the fee, period.
Well, and mostly the defrauding of attorneys was based on the escrow account, right?
Yeah, when an attorney
And
receives
you
money.
didn't even have an escrow account,
No.
because you weren't in private practice.
Right.
Gotcha.
And what was I gonna steal, paper clips?
I was only mentioning it as to the pushback that we've received
Right,
from
right.
these suggestions.
Yeah.
All right, let's move on, item 7.02. House Bill 36, hydrolysis.
Representative Rutherford of the Ohio 31st General Assembly has actually introduced House Bill 36 that would authorize our board to license and regulate alkaline hydrolysis. I'm giving you his testimony in detail. I've also attached it as well and attached the bill and the bill summary for you. Some of the items that I would like you to consider for discussion is that as we are looking to potentially issue crematory operator permits, this bill doesn't include any kind of issuance of that type, or operator, such as operator permits for alkaline hydrolysis. It does talk about alkaline hydrolysis, but no permit operators for it. So these are just items that you may want to consider whether you want to talk to Mr. Rutherford or Representative Rutherford about. The bill adds alkaline hydrolysis to the crematory review board, but one of the things that you've talked about is striking the crematory review board. The bill includes a much lower fee to license an alkaline hydrolysis facility, which is $200, which actually makes it $150 less than a crematory. And the forfeitures associated to it are much less as well. They've listed those at from $100 to $5,000, whereas the other licenses that this board regulates are $500 to $10,000.
So who's behind this? Not the legislator, is it, what's his name over there that has the hydrolysis machine? Edwards?
I do not know, I've not spoken to Representative Rutherford.
Where's House District 51?
I
Do we know?
Do you know that? Well, if they're going to get a proposed legislation, it obviously will probably start to go through the process, but maybe you should have a conversation with regarding getting the fees and licensing amounts in order, the forfeiture amounts and all that stuff, if it's going to be under our board, which I'm assuming would fall under our board since crematories do.
Was there any other items that you had thought of or wanted to include in any discussions?
They probably would have no problem just wrapping this up into 4717, I'm sure, right? So we just want to stay consistent with all of our other licenses.
Right. So I mean, some of what they're talking about contradicts some of the things that you're considering for those. So I think we just need to be on the same page whether you want to oppose some of those things, whether we want to work with Rutherford to maybe incorporate them, see them completely separate, or at least clean up that there's not consistency in this bill with the rest of our language.
Well, because right now we say that this is not a required, a legal
disposition.
Right. Our statute says that, correct?
Mm-hmm. It doesn't say that it just doesn't include anything for alkaline hydrolysis.
so we don't recognize it.
I thought we had to make a determination of an unauthorized form of disposition.
I just found Rutherford is from Butler County.
Or is that it? Well, that's all right, that's all right.
Oxford.
What's that?
Oxford.
Southwest?
Just another suggestion, we should probably maybe solicit the states that have approved it and look at what they have in their statute.
One thing, and Tom could probably speak to this as well, we recently met with 20 other states' funeral boards. There is, only a handful that actually have alkaline hydrolysis, although Canada also has it as well in some of their provinces, but not all. And all of them told us though that it didn't quickly take off, and that even in a large state like Florida, they really only have 3 alkaline hydrolysis machines. So even though they adopted it, it wasn't kind of a widespread where everybody wanted one and opened up an alkaline hydrolysis facility. But this language is very similar to the other states that do have it. Very completely different from the province in Canada, but that's because they have totally different requirements for it.
Is the fee similar to the other cases? Is that where they came up with the fee?
These fees?
Yeah.
Right, I'm just saying, I would think any form of disposition should be the same fee.
You mean the fee to get the license?
Right.
No. They're all different depending on the state. And they're, like the $200 isn't, ours is, it's not even our old crematory price. We were at $250, so I'm not sure where those fee index came from at all.
As far as cost to the consumer, it was much higher than cremation.
Well, what was much higher, the actual marketing cost?
I want hydrolyze you instead of cremating. It's going to cost me a lot more.
We used to do the unit was around 300,000 versus 100.
So the actual unit is about $200,000 more than a report.
When somebody talked to me about it, it wasn't that much.
Well, I think we need to address that with them. Yeah, don't you?
I don't think this needs to be in the form of a motion, but I think we need to be on the same page with Rutherford, so, just so we know that. Is that what you're referring to?
Yeah.
So I will hold conversations with Representative Rutherford and report back next month. At this point, it's only been referred to a committee, and they did have one hearing, but the only testimony was Rutherford so far, so there's not motion scheduled at this point for it, so I'll schedule a meeting with them.
Items 8.01, items of interest.
Some information for you. President Fleming and I attended the annual meeting of the conference. The state funeral boards discussed and voted on the adoption of the attached and attached at 40 Model Practice Act for funeral services. And as a delegate from Ohio, I voted against the adoption of the act due to the requirements for licensure included in the Model Practice Act were significantly less than those that Ohio has in current legislation. I was also a speaker in a panel presentation at the conference on alternative certifications and what's on the horizon. During the course of the conference, both the president and I spoke with individuals in roundtable forums with representatives from 28 other state funeral boards. We continually brought up the conversation about misappropriation of pre-need, and we made inquiries regarding their procedures, techniques, tools, and laws that they use to combat the issue. Unfortunately, none had any new approaches to offer to Ohio that we were not already doing, and in many cases, most indicated to us that Ohio was a model that they looked at, and they sought direction from in those types of cases. Another piece of information is that the annual pre-need audit reports that are due March 31st, as of just the 12th, the last week Thursday, we've only received 38% of the total of those reports. So there'll be a lot of information probably on the April agenda about failures to respond to the pre-need.
If I may, you you attended this conference, did you learn anything that other states were doing that Ohio isn't doing?
Can I comment?
Sure.
The Model Practice Act that she just spoke about was adopted, and we were the only state that voted against it because it would lower our standards to go there, which you can still have the standards, but the one good thing that I saw of that, it would bring a lot of states that are well below that standard up to par, which was a very good thing. As far as new stuff that we learned, the Model Practice Act was the big thing because they've been working on this in committee. Then this is the first conference that it was presented at, wasn't it?
Yes.
Okay, that's what I thought. This was the first or second conference I've been to in 5 years, and I will say I like the format better this year. They had more roundtabling and speaking, and we did get to speak about pre-need issues that we all have to be concerned with, and we're looking for that out-of-the-box idea, from someone that they could tell us too, But as Vanessa said, most of them said, well, we usually look to Ohio when we need to do something. So
The two things that we were able to determine that some have that we don't is that some do have the fund and some do have that direct deposit. But we've attempted those in the past and not been successful, so it's just whether we want to determine whether we want to make that attempt again. But as far as any other things that they're doing, in most cases, a lot of the states are a little bit farther behind from where we are. For instance, when we talk about their requirements for licensure being significantly less than ours, many states don't require any type of education to become a funeral director. And they can be an apprentice only and must be just 18 years of age, that sort of thing. This Model Practice Act took that to a bit higher because it included a requirement for at least an associate's degree and a mortuary science school, which is still much less than where we're at. We found out that because Ohio probably has such a strong funeral directors association and Buckeyes Association for funeral directors as well, and that both of those associations have, worked closely with the state. We have gotten farther in legislation and regulation than many other states have as far as the funeral industry. So in a lot of cases, specifically Pennsylvania, we talked about the naming requirements in Pennsylvania. And in talking to Pennsylvania, the reason why theirs mirrors ours is ours was written first. And they utilized ours as the template. So in many cases, Ohio is being utilized as the template and as the model. Just an update in case anybody tried to contact me the last week of March, I will be taking a bereavement leave to attend the memorial service for the United States.
okay. 8.02, the budget review of invoices.
We are currently ending the third quarter of the fiscal year, and so that is our budget overview as of March 10th. And then we've had a small number of disbursements. Is there any questions on any of those?
9.01, monthly inspection. Okay.
The overview is the summary sheet for both inspectors attached, and the next one is the detail for each inspection completed.
item 10.01, Federation of Associations of Regulatory Boards, FARB.
These are items carried over from last month. The first one, the FARB conference, both Tom and Greg and I attended. We quickly, one of the things that was discussed in a large group setting were issues experienced by other state regulatory boards. At this conference were not just funeral regulatory boards, there were all regulatory boards, including medical, nursing, pharmacy, optometry, funeral boards, and all types of licensing boards. All of them said they were experiencing vacant seats on the boards that were not being filled. AAGs not completing cases on time, and then the licensee never received discipline, and lack of funding, no resources to support the duties of the board. Discussions regarding occupational licensing were whose interests are being served and what cost to the society, and could the funeral, so this was a question that we brought back, was could the funeral industry be regulated by a private quality assurance mechanism, such as an insurance coverage, who would be liable if the insured received malpractice. That was one question that was brought across all regulatory boards. There was discussion on why the text is in there, but when there was agreement basically that when there's no benefit to the public, and the only reason is to benefit the industry, that we've seen that courts have been striking those types of laws down. And this is the rest of the minutes if you want me to go I can, or if you have any questions about it.
Any questions regarding the FARB conference?
One of the things I would point out was in discussions about technology and practice, there are boards that are actually going to teleconferences due to their lack of resources, so they're not actually meeting in person. And I don't think that would work for us as far as what the Sunshine Law requires us to do, but that is something that other boards are actually doing. And we may want to look at adding language for funeral services that are sold online. That's not something we've discussed in the past. But there are all different types of licensing boards, including there was even an example that a veterinarian is now, I guess, seeing his patients via Skype and not actually laying hands on the animals. But there was a recommendation that we look at adding language about online sale of services. And there was even a question about when was the last time people had reviewed how they define what funeral directing is, essentially. We address that here. And when you see, I talk about these small group settings, each one of us that attended a different group. So we could probably give you more detail about at least 3 of the 4 groups. Any questions? I can go into operations.
Yep, go ahead.
This was an update from last month that we carried forward. Wallet cards were mailed out. All the licensees probably aware of that because they received them. And this is just telling you that the annual premium report update as of our last meeting, and the note of the closing of the office, and that we would be attending the contract conference and what that model practice act was. Is there a question?
Last one, they just go around.
Okay. Then there was a reminder that, and so this would be relevant still now, that the annual financial disclosure statements are due by Wednesday, April 15th. So please make sure that you've gotten those in. Then there was the inspection overview, the 2 items that would have been presented at February's meeting. I can assure you that all of the violations that were listed there have been corrected. Then, do you think about the inspections? I also had included the executive budget had been released, and I gave you the amounts. They gave us a 0% increase for 15, and a 4% increase, which was $30,000 in 16. That 4% increase was for DAS operating in personnel of 6.7% between state fiscal 14 and 15. And it was notifying you that I was scheduled for budget testimony on the 3rd, which I did provide. And I also gave you the blue book, which is the budget recommendation presented by the administration and the hearing schedule.
Any questions on any of the carryovers from last month? Or nothing? Okay. Okay. Item 11.01, request for board member Tanner for executive session.
Mr. Chairman, I'd make a motion that the Board of Embalmers and the Funeral Board go into executive session pursuant to Ohio Revised Code Section 121.22G1 for the sole purpose of discussing the employment and discipline of a public employee.
Is there a second?
Second.
Is there discussion?
I'm a little concerned about doing this because of the advice that we've received from the HC's office in the past about executive sessions. We only have one employee that this board's responsible for, a public employee, and that's Vanessa. And I would just feel more comfortable knowing what this is about before I vote to go into executive session. Just based on the brow beating that we've received from the Attorney General's office in the past that I've lived through it. And so I'm planning on voting no to go into executive session unless I hear something that merits me to vote yes.
If we do go into executive session, just it is for discussion purposes only. No notes will be taken. If you go, no votes or no decisions will be made in that process. We'll proceed with this.
Mr. Chairman, I would also want our Assistant Attorney General to be present.
I think what we have to do is if we go into it, if we vote on that, everyone but the board members leave, and then we can invite you back in.
But you also need to turn the recording off, but you may invite anybody back in that you choose to have.
Okay.
But everybody leaves.
Is the discussion correct?
Did I read correctly to you?
No, again, this is just an example of the inaccurate transcription. What I said was that we would go into executive session for the purpose of discussing employment and discipline. And I'm not sure who put dismissal in. I said discipline.
Well, there was nothing prepared ahead of time. That was me trying to take what I.
She just put it in. Just misunderstood.
This is why I want a stenographer here, to read back exactly what's said. Because we can't go back now and play that because there's no audio here that can pick up some of the people on the far end who speak softly.
Can you correct that?
I think it means that. Well,
Employment and discipline.
Looks like there's going to be discussion on whether to invite the AAG in, which would be something to turn myself that way. You should have that in the open meeting before you go out, so if it's not unanimous, we'll need to discuss that also. when, once one motion carries, then we'll need to do the second.
Second motion to have you come in.
But we'll need to do all that on the record. So you want
Right,
to
so
decide
do it
if you want to go
before
into executive.
Before we take the vote.
Probably the best.
And then I'm also making a motion that the Assistant Attorney General be present during the executive session.
Second.
Any discussion on that?
Let's go under discussion. So I know,
How come we have two motions on the floor at the same time?
You need one and then you have the second one.
So we're not
So
addressing this one.
The Attorney General.
I think right now you're addressing the Attorney General issue and then you're going to go to the executive session while Vanessa's typing, is my understanding. It's up to you guys how you want to do it, what you want to do.
I'm confused, that's why.
I get confused.
Yeah.
Go for that.
Okay, we need to address you first, vote on whether the Attorney General. Okay. Because if that's a yes or no, that's fine. And then we need to vote on whether we're going into executive session.
Yes, and that needs to be a roll call. So once you vote that, you need to go directly into it and then.
And for whatever it's worth, on the State Cosmetology Board, whenever we would go into an executive session, we simply decided who we wanted in there, whether we wanted the director in there, whether we wanted the AG in there, or a staff counsel, or whoever. We never did it with a motion. But I'm not saying it's right or wrong, I'm just telling you that's the way we did it.
I think you have to go in on motion, if I'm correct, from the Sunshine Law to go out of executive session and the initial.
That's right, he's saying for who you brought in.
Oh,
That's
you
usually-
brought it, I'm sorry.
If the board agrees, then no, you can just bring in who's needed, since I have a feeling there will be debate over this, it's probably better to have a motion and actually make it a little cleaner and everybody decide that way.
So the first one we're considering is the motion to go into executive session. This one. For our-
That's the one that was on the floor.
That's the first motion.
So should we take back the motion for a minute to do the, do you want to send the motion and go into executive session so we can address the Attorney General first? But no, he's rescinding that,
This one?
that motion right now, but don't take it down.
Just copy it and
Yeah.
then fill the new one in.
I think this can't communicate with this, with two motions at the same time. I have the motion that the Assistant Attorney General be present during the executive session, which hasn't been voted on.
That's what we're acting on right now.
Okay, so I'm taking that one.
Okay.
Yeah, that's good.
And you seconded that, correct, Linda?
Yes.
Great, we call roll.
Yes.
Mr. Cannon?
Yes.
Ms. Betzer?
Yes.
Mr. Fleming?
Yes.
Mr. Boyer?
yes.
Mr. Wasco?
No.
Mr. Black?
That's, it was a question, I know we're in the middle of the vote. My question too is, our board's made up of 7 individuals, or 7, supposed to be 7 appointments. We only have 5 positions filled. So what is the majority on the vote when there's only 5 and 7 positions filled?
Your language actually talks to a quorum has to be 4 individuals, of which at least 3 must be licensees. It also says in your language that you need the concurrence of 4 votes to make any item pass.
And this motion here is just to have her present during the executive session. That's
Yes.
this vote. Well, I believe that should be done, so yes.
Okay. 4-1, that motion carried.
I think it's having trouble recognizing 2 motions, but I have Tanner, Betzer, Boyer, and Fleming as yes, and Wasco as no, and the motion carries. Then I would have the other motion.
Sure. I move that the Board of Embalmers and Funeral Board go into executive session pursuant to Ohio Revised Code Section 121.22G1 for the sole purpose of discussing the employment or discipline or complaint of a public employee.
Second.
Any discussion?
That's a different motion than the first motion.
Yeah.
You made,
He rescinded that.
I added the word complaint.
for the sole purpose of discussing the employment, discipline,
Or complaint of a public employee.
Further discussion?
Did you get all? Got a second? Yes, discussion.
Now, if there's been a complaint made, or when's that supposed to be seen or shown?
if there's a complaint, I actually have a right to a public hearing.
This statute specifically lists the word complaint as one of the reasons for an executive session. It says or.
It doesn't. It says, a public body may not hold an executive session to consider the investigation of charges or complaint against a public employee, official, licensee, or regulated individual, unless the employee, official, licensee, or regulated individual requests a public hearing. As the only public employee that you could consider this for, I will request a public hearing.
I think you can do anything except the or complaint part.
I'm sorry?
The reason was valid up until the or complaint part, I believe, but I can't pull up the code for the exact language.
All right, I withdraw that motion then, and I will reinstate my previous motion, moving the Board of Embalmers and Funeral Board to go into executive session pursuant to Ohio Revised Code Section 121.22G1 for the sole purpose of discussing the employment and discipline of a public employee.
Second.
I now have a motion to go into executive session for Ohio Revised Code 121.22G1 for the sole purpose of discussing the employment and discipline of a public employee, made by Mr. Tanner and seconded by Mrs. Betzer.
That's correct, we should go back to the current. Okay, we'll open for discussion one more time. Any further discussion? Roll call.
Mr. Tanner?
Yes.
Ms. Betzer?
Yes.
Mr. Fleming?
No.
Mr. Boyer?
Pass.
I'm sorry, what did you say?
I did a pass.
What's this pass? I don't
You're
understand.
allowed to pass, you're allowed to abstain. So.
Okay, is that correct, sir?
I've never heard pass. Would that be the same as abstain, or are you just wanting them to come back to you?
Well, there's sometimes they went out certain orders on how people came onto the board. And when they first brought me onto the board, they had placed me first. And I felt at that time I didn't have the experience or the knowledge to actually make a decision at the time. So it was told by Carla Fitzpatrick, that there were options, that you could abstain, you could pass.
Passes come back to you.
So you just want them to come back to you?
Right.
Okay. Problem with that, as long as he does vote, he eventually will have to yes, no, or
I've just never experienced anything like that.
abstain.
It has been my experience on previous board that it's a rolling vote. You don't go in the same order, that the order that you call, the roll changes each time. but I've never experienced a board doing it.
Continue to roll.
So I need to vote, I can vote no.
Mr. Monica?
No.
Motion fails.
Okay. Any other comment or business to come before the board? I have a motion for adjournment.
So moved.
Second.
All in favor?